Hi there, this is Kathy Graham. Could someone let me know by typing into the chat box that you can hear me? Okay. Good afternoon. This is Kathy Graham with Pay Entry, and today we're going to talk about the litigation against employers during COVID-19 or the pandemic. If you cannot hear me, if you could type into the chat on your screen and let me know that, then I will see what I can do about it. Last week we had some awful technical difficulties. That's why we're doing that here today again. You can also ask questions by typing that into the chat, and we will answer those at the end of the session. I wanted to let you know that I will be sending all attendees a copy of the presentation in PowerPoint format today, so that if you want to take notes today and going forward, you'll have that as a piece of reference material. So let's start talking about litigation against employers during this pandemic period. We're going to talk about today, we're going to talk about the current activity, the types of lawsuits that are out there now. And you think that people have better things to do than to sue their employer, but they have all the time in the world on their hands right now, and attorneys that are anxious to help them, some attorneys, not all. But we're going to talk about those lawsuits that occur because of paid leave laws that are out there, discrimination issues, wrongful termination, wage and hour issues, layoff notices, and workers' compensation claims. As of mid-June, and now we're mid-July, almost 250 lawsuits have been filed at the federal level in 120 days. And I would say that maybe a few of them, because there are workers' comp, states have different laws, so there are different rules in different states. But the majority of them have been filed at the federal level, and those already in existence, those laws that are already in existence. The Families First Coronavirus Response Act, which came out in March of this year, I believe. OSHA has addressed the issues, and some laws are being violated there. So, and then the Department of Labor, which is the DOL. Those are the agencies that are seeing these. The EEOC is also aware of any discrimination claims that come out. The paid leave lawsuits, and there are a ton of those, more than there are of any other. The Families First Coronavirus Response Act requires employers to provide up to 80 hours of paid sick leave for reasons listed in the law, which are related to COVID-19, and an additional 10 weeks of unpaid leave for eligible employees for school and childcare closures due to COVID-19. So the first 80 hours is pretty much for COVID-19 quarantine, and or having someone in your family or have need to be taken care of because of COVID-19. Next week, no, it's not next week, tomorrow, we have a recap and update on all of the leave laws since the first of the year. And if you need a refresher course on that will happen tomorrow at 2 o'clock. So lawsuits have been filed regarding employees alleging that they were denied this new paid leave, that they weren't paid for it, even though they were given the time off, or that they've been retaliated against for seeking that leave because the employer is not um, following the rules of the law. Employers need to make sure that their leave programs are coordinated to meet all federal, state, and local requirements. Sometimes the local requirements, especially in California, may be more strict than even the federal. And be aware of all the requirements to pay for leave under these new COVID rules, because if you don't, that's where the lawsuits come about. As far as discrimination, age and pregnancy top the list on the EEOC charts. The EEOC prohibits employers from preventing older employers and employees and pregnant workers from returning to work if they want to do so. So you can't stand in their way, even though you think as the employer you're acting in the best interest of the employee by not bringing them back into a workplace full of people. Well, you can't treat them differently than other employees. They have to be treated the same, even though it feels better to you to treat them differently. It is against the non-discrimination rules to do that. Under discrimination lawsuits, the ADA, which is the Americans with Disabilities Act, is another source of discrimination claims during this time. The act actually governs what medical information that you can use as an employer from employees and how you request it and how you use it and how you store it, basically how you share it, any of that. It requires employers to provide reasonable accommodations to those employees who have disabilities or those who are at high risk for severe illness from the coronavirus. So if you have someone that has an immune system deficiency, they're going through cancer treatment, or they have a known problem, or they're coming forward to tell you that they have asthma, for example. Those individuals need to be accommodated coming back into the workplace. And you need to have a one-on-one discussion with the individual to find out what it would take for them to um, not be at high risk coming back into the environment. Potentially, it could be that they're given an office where they can close the door, or they are, can work at home. There are other, different ways to handle different accommodations. Discrimination claims can surface as companies decide what employees are coming back to work and when. That's a blessed problem, actually. When we're looking at now Los Angeles maybe going under another lockdown, employers need to consider your current business needs, your stay-at-home restrictions in the area where you are, and also any other issues that you need to take before people come back to work for health precautions. So be prepared to engage, as we just discussed, an interactive process under the ADA to address the concerns of employees fearful of returning to work because of a health condition that they have. If you have someone that is fearful of returning to work just because they're afraid to come back to work, then that doesn't count. Fear is not a reason not to return to work. If they have a medical condition or a suppressed immune system or something like that, and you can address that and find an accommodation for it, that is the way to do that. If they're just afraid, as long as you provide a safe work environment that they can come back into, then you are not violating any laws by having them come back to work. Avoid blanket policies that require high-risk employees. We just talked about this, like older or pregnant, to continue to work from home, even though they might like that. Don't single them out because it could come back to bite you. Even though you're being a nice employer, it may be something, because it is considered to be discrimination, that the employee could find later on to be something they have a problem with. The EEOC just recently issued some new guidance on workplace protection rules that show you how to um, determine or if you have a safe work environment and how to take the steps to get to that level. This will be sent to you in your packet so that you can log on to this website and get additional information. Wage and hour lawsuits, this is going to be another big one. I said we had about 250 lawsuits so far. That's going to escalate pretty quickly as we get further and further into this because working at home is allowing a rise in unpaid wages. You have hourly employees that work at home, and they're not recording their time correctly or properly or accurately. Then later on, they decide that they did work some overtime, and you owe them some money. It could turn into a court case if someone is unhappy with you, and maybe they've been terminated for another reason, or they've just decided that it is time to get the money that's owed to them. So employers need to be very strict in the way that you have people keeping track of their time. Make sure that your non-exempt or your hourly people document all their work hours, even if they're not, if they're working off the clock. And you find out about it, that should be rise for disciplinary action. And your policies and procedures should say that. If you record your time improperly, then that's cause for disciplinary action. Require written approval prior to the overtime work, if at all possible, so that you have a record of the fact that you have requested that overtime and you're paying it. But make sure that the hours that they're turning in are accurate. If you don't have a timekeeping system and they're just recording it on a time sheet at home right now, then make sure that they sign and date it, that it is accurate. This is a big area of concern. In layoffs, many of you will not have to deal with this law because it does, you have to have a certain number of employees. But the WARN Act, which is the Worker Adjustment and Retraining Notification Act, requires that you give 60-day notice to workers when they're laid off for an extended period of time or when you close a business. And this act applies if your facility closed and at least 50 people lost their jobs, if at least 500 full-time employees at a facility lost their jobs, or at least 50 full-time employees lost their jobs, and the number of those losing jobs exceeded a third, or more than 33% of all employees at the facility. If you have questions about this one as to whether or not it applies to you, then please let me know. As far as workers' comp goes, at this point in time, no current lawsuits have been filed. Um, the legal experts, however, do believe that this will climb as families or employees who have died from the virus will file claims against their employers, saying that they got the virus at work, that they contracted it at work, and the work place was not protected, or the employees were not protected as they should have been in the workplace. So we will see a rise in this. It's going to just take a little bit of time. And also several states have passed legislation that makes it easier for workers to file successful claims under the workers' comp insurance company. So this, I think we'll see some evolution on this, that it probably will get to a level where most states have something that allows employees to bring these kinds of charges. Wrongful termination has been around forever. The majority of states in the United States are what we call at-will states. That means that you can terminate an employee for any reason, and the employee can leave for any reason. It doesn't matter. There are some situations, however, that where in courts wrongful termination does not hold up, and in certain states there are different rules. So, but the court cases that we're seeing right now, for example, are well, they include employees that have been terminated because they didn't report to work, when a stay-at-home order was in place, and it was a non-essential business. So it would be, a non-essential business like a hair salon, let's just say, and told to come to work and didn't, and was fired for it. That is absolutely wrongful termination, and that goes against the public policy rules. If another employee complained that they were not protected, that PPE was not available for employees like masks and gloves or face coverings, and another expressing concern to the employer when coworkers that had symptoms of the virus were allowed to continue to work right alongside them. So these sound like valid complaints. There are companies out there that aren't complying with the rules that are in place now for creating a safe workplace or paying for paid leave during, the COVID outbreak. In a wrongful termination situation, if you have documentation that shows that your action was unrelated to the complaint that the worker had, or your actions were unrelated to that complaint, then you have a much stronger chance of being able to defend yourself against a charge of wrongful termination. Make sure that you record complaints and that you investigate and record the results of your investigations. If it is a complaint about a lack of PPE or someone was fired because they wouldn't come to work, then you need to investigate that. And if you are terminating an employee, make sure you carefully document the reasons so that the employee doesn't come back and say it wasn't for that. It was because I wouldn't do so and so, or I wouldn't work next to somebody who had symptoms of the virus or something like that. So documentation in HR is essential. Two things in HR that are that are essential. One is documentation, and the other is consistency. So those two things need to be at the front of your HR Bible. So employers today need to understand the laws that are currently in place, and then keep your eye on the horizon because rules change, and rules are clarified, and you may be doing something differently than you were told to do at first, and now they've changed their mind about how the law should read. Review your current policies and procedures to make sure that you have compliant employee handbooks and policies and procedures about coming to work during this time frame. Above all, educate your managers and supervisors. A lot of your problems do happen on the front line. And if your managers and supervisors don't know the rules or don't know how to handle certain things, they can get you in more trouble than you can get yourself into. So make sure that there's training for your managers. There is training for your managers and your supervisors. In layoffs or return to work actions, make sure that you're selecting employees based on your current company needs and do it in a non-discriminatory manner to make sure that you're not selecting all one group of people or a certain age group or a certain um, other demographic that might be considered discriminatory. So it's very important to second guess yourself on when you're doing a layoff or when you're bringing people back to work. So are there any questions? You can type those into the chat room, and I am going to unmute everyone right now if I can. Let's see. I am unmuting you, so if for some reason the chat is not working, you can let me know by just sharing this verbally.
I don't have any questions.
All right, and you can hear me well on the throughout the program?
Yes.
All right, thank you very much. Well, that is going to end today's presentation on lawsuits. I will be doing another one of these probably in August to do an update on what current legislation or current lawsuits are out there and how you can prepare yourself so that you don't end up with one. There are some additional um, lawsuits that are in the courts that we're waiting to see how they turn out. And then we will be getting back to you with some more guidance on this type of thing. But if you have any questions after this, please just reach out to me. My name again is Kathy Graham. I'm head of the HR services area, and I am here to help you. You have access to me with your pay entry contract to ask any question that you want to through email or telephone. So please reach out to me and I can help you solve your problems or maybe not all your problems, but maybe I can help you solve some of your problems and answer some of your questions. So with that being said, I will end the slideshow and we'll send you a copy of this immediately following. If you have any questions, please reach out and let me know. Thank you very much for attending and have a great day.